All right, it is 8:30 and you have come to the State's Powers Committee. Representative West, would you lead us in a prayer as we open our committee?
Y'all pray with me. Father in heaven, we thank you for the day. Thank you, Lord, for your mercy and your grace that you so easily bestow upon us. Father, I just pray for this committee meeting today. Pray, Father, that your will would be done, and that, Father, we just ask that you would be with our country, that you would be with our upcoming elections, Father, that we can see that you're still in control, and we trust you. And Father, again, just protect us today, protect this country, and God bless the state of Oklahoma. And I ask these things in Jesus' name. Amen.
Thank you, Representative West. Representative Gann, you have interim study 24031, surveillance cameras and warrantless searches. And so with that, I'm going to turn it over to you. Thank you.
Thank you, Madam Chair, and good morning and welcome to the interim study on surveillance cameras and warrantless searches. This is the State Powers Committee, and for those listening online, I'm Tom Gann, State Representative in District 8. And I want to thank Chairman Stiegel for allowing us to be here this morning and have this study. And we did have some issues with, he had to go back east and be with the people and help the people in North Carolina, and so we're glad he's there. I'll be presenting a PowerPoint presentation first, and then we'll be hearing from City Council members from Pryor. And then also we'll be hearing from an OK2A organization, and then we'll bookend the end of the study with the Senior Policy Counsel, Chad Marlowe from the American Civil Liberties Union, who will join us online. Whoa, there. Okay, there we go. Duty first. Before we begin, I think it's necessary to state what we're trying to do here today. The interim study is to reveal and review the concerns with the massive data collection taking place in American society. It is a concern that transcends the normative left-right dichotomy of political viewpoints, because it's about personal freedom, that we have a God-given right to our privacy enumerated in the 4th and 14th Amendments. And Teddy Roosevelt said the three things that would destroy America are prosperity at any price, peace at any price, and safety first instead of duty first. We are for the rule of law, and being for the rule of law requires us to have law enforcement. Nowhere in the Constitution does it require government to make you safe. No, the Constitution is a restriction on government to keep us free. Even though we all want to be safe, we have a duty first to ensure the laws that we make respect the rights granted by God and preserved by the U.S. and Oklahoma Constitutions. At the end of the day, lawmakers and law enforcement officers alike swore an oath to uphold and defend the Constitutions. On this particular issue, automated license plate readers in our state law is inadequate. Our state law is inadequate with the fast-paced technological advances being made, and unfortunately, how those advances are used without regard to due process. My desire is to have these concerns taken into consideration as we work with the Senate and other lawmakers to develop law to govern the activity already taking place. Another element of research that I found was John Locke, who had a great he was an inspiration to our founding fathers. He's quoted often and was instrumental in just his thoughts and things were instrumental in the development of the Constitution of the United States. And he says this: wherever law ends, tyranny begins. If the law be transgressed to another's harm, and whosoever in authority exceeds the power given him by the law, and makes use of the force he has under his command to compass that upon the subject, which the law allows not, ceases in that to be a magistrate, and without and acting without authority may be opposed as any other man who by force invades the rights of another. So I like to always take the approach to, as a former auditor, we always had the saying that we compare what is to the way it should be, and we always have to figure out what is before we proceed with that. And I always like to take that approach. And so with that approach, we'll begin with Senate Bill 359, which is enacted in 2016. And it provided the framework to allow the use of the cameras to identify uninsured motorists who violate the compulsory insurance law. And the law provided revenue to the DA Council, the District Attorney Council, and it was intent to reduce the number of insured vehicles on the roads. And before this bill passed, we operated under a law that allowed law enforcement to take tags away from motorists who did not have basic insurance required by the state. And that, I think, came into play in 2014, and then in 2016, 359 was passed in the A and B committee. And during that committee meeting, if you go out and listen to the tape, they expressed some of the very concerns that we're facing today and what we're looking at on and the issues at hand today. One of the comments was said that it was solely that all we're looking to use it for is uninsured motorists. That was a comment by one of the presenters there on Senate Bill 359. And it was also stated, and I think this is by the lobbyist that presented and was asked these questions, we're not anticipating that these blanket the state. And he was talking about the cameras that were used. And the law does reflect that the cameras that for the compulsory insurance law were to be in population centers of 100,000 or more. And then there was a comment by a wise legislator who said, you're unleashing a new layer of technology. And this is almost prophetic. Said that one more step would be a huge step towards a totally different application. And then he said, you could monitor traffic in every way imaginable, and at that point, it gets to be more than just car plates and vehicles. And so the wise legislator was very prophetic in those statements. Now, Senate Bill 1056 was another bill that was passed in 2016 dealing with automated license plate readers, and this is in Title 47 as well, Section 11-1401.216B, and it was a bill passed for the Oklahoma Turnpike Authority, and law enforcement was wanting to access their license plate reader data, and yet they required a warrant, a subpoena, or order it by the court in order for them to have that. And then that was restated in the Senate interim study when I believe it was OTA presented. I believe that was the man that was the head of OTA or ODOT reiterated that in order to get that information, they must have a search warrant, a subpoena, or court order. But in that, as stated in 359, the law restricts the collection of license plate data through the use of automated license plate reader system only to enforce the compulsory insurance law or as otherwise permitted by law. So we have a dichotomy here. We have 359 that is solely focused on the compulsory insurance law. Then we have 1056 that concentrated on the allowance of license plate reader being accessed by law enforcement with those three protections of due process. And that's what the other side is lacking. And as far as I know, 1056 is the only other law that deals with license plate readers. And in that passage of that law in that committee meeting, there were some things that were said on the floor and when it was being presented. And it says, said by Representative Bands, it says, it's my understanding that the interpretation with the Oklahoma Turnpike Authority, as it's statutorily stated now, they do not have the authority to turn that over even with a warrant. So this is bringing the statutory language into line with what they are given the authority, provided that they have a duly issued warrant, subpoena, court order issued by the proper authorities granting protection to the Fourth Amendment. So they were concerned about that with the Turnpike Authority, and of course, that's governmental. The government owns those tag readers. They have a responsibility to make sure due process is followed by that. So the point I was making, it was recognized by all parties involved the necessity to have statutory authority and without any ambiguous parameters. And then last spring, we had 1620, which was offered into the Senate, and that bill offered several things. It authorized the use of automated license plate reader systems on rights-of-way of state highways, and it allowed for license plate reader systems to be scanned and identify vehicles and associated plates to identify stolen vehicles and those involved in active investigations, missing and endangered persons, and vehicles registered as a match with the NICS Center or National Crime Information Center and any other relevant database. And so 1620 was the bill that made it to the floor. The House version of it did not make it. He didn't bring it forward. The bill was defeated by a large margin of those in the Senate chamber floor that day. And it's kind of interesting, though, with this bill, what it did do, it's a lot about what it didn't do, and it really didn't provide the protections that we were looking for in a piece of legislation like that. It allowed the expansion and the use of the automated license plate readers, but there was really nothing to say about due process or any other issue like that. So I think it's important that any legislation to be considered on this subject must ensure and have in it the rights of lawful citizens and protections granted by the Fourth Amendment. Okay, this is the third party, non-governmental organization, private business that we're dealing with. This is the face of Flock. This is Garrett Langley. And he was interviewed by Fox 6 News out of Milwaukee, Wisconsin. The reporter was Brian Polson. And Brian Polson, in his statement, said it's been described as a form of mass surveillance unlike anything we've seen in American life. And so his goal, this is his vision for America. And this is the scary part. He said, I envision an America where no crime no longer exists. I envision a future with flock camera on every street corner. I don't think that's a workable situation. It's in total disregard for the lawful protection of the Fourth Amendment rights of innocent citizens. We have, as this technology expands and its use is unfettered, and there are many vendors soliciting businesses with governmental entities with this technology, but the one that seems to plague Oklahoma the worst is Flock. We had a billboard on the Creek Turnpike if you were heading to Oklahoma City that said, just before the 44 on-ramp off the creek, it said, Oklahomans to join the Flock. And so I think his plan is working so far. I mean, his endeavor to set himself up since he was a college student has really given him a lot of great success with this industry. He's worth, I think, at $3.5 billion, and he's on track at the current rate to put a flock camera on every corner. It's a noble idea to try to rid America, eliminate crime, but I think it's naive to think that a camera on a pole capturing tags of vehicles are going to change the heart of men. I don't think that's possible. So with this self-serving, naive endeavor, though, it's ironic. The irony is not lost on thinking people by the fact that in practice, the Flock CEO facilitates the violation of the constitutional rights of Americans, all while envisioning American where crime no longer exists. You simply cannot hide behind the corporate veil and enable a purveyance of private data on citizens against their consent and incite others to violate the Fourth and 14th Amendment on American citizens. You can't avoid the contradiction as you try to eliminate crime in America. You cannot eliminate crime by committing crime. Violating constitutional rights is a crime. Flock network is just a web of interconnected surveillance cameras, and these devices are located in retail outlets, homeowner associations, public right-of-ways. They scan over 1 billion vehicles. They're appearing everywhere. The network now scans over 1 billion vehicles a month. The solar-powered devices are cost-effective, they're easy to deploy, and they form an interconnected and omnipresent surveillance network across the nation. Unlike traditional surveillance systems, which operate in isolation, Flock devices integrate into a broader network, enabling real-time monitoring and information sharing among thousands of Flock users at numerous law enforcement agencies at all levels of state and local federal government. And Flock devices profile, or what they call within their company, Flock probe, each vehicle passing, capturing, identifying details of the vehicle. And this particular camera is located in Claremore, just outside of Lowe's. And as I was saying, they offer to empower your community and to create these virtual perimeters with a Flock camera on every corner in neighborhoods and tap into HOA security systems and things. And so this is really no longer about just tracking cars with this company. It's the use of the technology is really ushering in what many are concerned about, a surveillance state. Build a community camera registry with ease. It even offers you to be able to register your camera website, and so everybody can access each other's videos. And this community has created the network across the state and nation. And then here's the Flock probe. Flock devices, vehicles, they're known as autometric profile of vehicles. They may take the tag number, but Flock also records the make, the model, the color, and also maybe a bumper sticker. It allows AI technology to create the profiles of the vehicle in relation to other vehicles that happen to be traveling in the same area. And anything that distinguishes the vehicle on its own is captured. I think another scary part about this is the sharing. Information is shared among Flock users at numerous law enforcement agencies without a warrant. And nationwide surveillance network is created. Local police departments seek approval for this system, and they are likely to present Flock network as the local-only system where local departments own the data. However, what they likely won't explain is the following, that there are thousands of Flock users in many other jurisdictions at all levels of government who will potentially have access to conduct warrantless searches on the local surveillance data. This potentially includes users from heavily politicized agencies like FBI and ATF. When the local police department gives federal Flock users access to their scan data, local law enforcement essentially establishes their city as just another node on a nationwide surveillance network on behalf of federal agencies that have little or no accountability to local voters. When these agencies act inappropriately and violate the constitutional rights of individuals, there is often little recourse available to the victims. This is because the officer is not subject to discipline by the local department where the target resides and exercise their rights as a voter and citizen. This sharing of data operates at two levels, a direct level and indirect level. Direct, many local departments have authorized direct sharing with Flock users from various law enforcement agencies across the nation. This direct sharing allows users from other departments to query, which is to search, the query is just another word for search, the travels of citizens from the host department. In a press release last session, it was disclosed that Dell City, Oklahoma was found to be sharing its citizens' data with out-of-state departments as exotic as the Kansas Bureau of Investigation, the Texas Financial Crimes Intelligence Center, and the U.S. Postal Service, while other departments were known to share with the FBI and ATF. Additional features of the flock system. Indirect sharing, then, even when an agency does not intend for their data to be shared with agencies such as the ATF or FBI, it can still be potentially filtered through various intelligence desks such as fusion centers. For example, an Oklahoma law enforcement agency that shares surveillance data with Department of Public Safety, most likely do, may have that data filtered through the Department of Public Safety's Fusion Center intelligence desk to federal and other government agencies. Thus, even when an agency states that it does not share with federal agencies, in practice it probably actually does. The search is simply potentially laundering through the middleman party. Additionally, an authorized flock user from the local agency might run queries or searches against the data at the request of those agencies that are not on the list of authorized agencies. For instance, a review of Wichita, Kansas search logs reveals multiple searches that appear to have been conducted on behalf of the controversial federal ATF agency, even though Wichita is not believed to have any officially authorized the direct sharing of data with the ATF. Database of past travels. Most commonly used feature of the flock system. This is a bothersome part of this. Uses searches or queried the database with flock probe data for past travel routes, and no warrant is required for this action. As an example, perhaps each day on their way to work, a driver passes near a known drug house or perhaps a seedy massage parlor. The flock user will simply enter the vehicle's characteristics into the system, recreate past travels, and observe that the target vehicle is frequently within the vicinity of the problematic location. This is potentially the foundation for building a probable cause, applying for a search warrant and additional investigation into the driver. And another thing is the selective enforcement issue. Constitutional principles are undermined whenever there is a selective enforcement. Arguably, when law enforcement uses technology to target one or a group of people but not others, or select certain crimes but not all, there is an issue of selective enforcement. The selective enforcement of flock technologies is well documented. For example, many, if not all, flock jurisdictions state that they do not use flock policies for immigration enforcement, creating the perception of a dual system of justice, one for citizens and another for illegal non-residents. By attempting to play by the rules, the latest political trends, and engaging in selective, politically driven law enforcement decisions, Flock's departments have undermined their authority to consistently apply the law to all and potentially opened up a powerful 14th Amendment case. The decisions of the Flock departments to cater to politics comes after the American Civil Liberties Union criticized Flock's competitor Vigilant, now owned by Motorola, for their integration with the U.S. Immigration and Customs Enforcement and the potential for using these systems for immigration enforcement purposes. This is Del City, Oklahoma, and these are the 65 entities that they share with, including the Texas Financial Crimes Intelligence Center. It shares with the U.S. Postal Inspection Service, Oklahoma State Bureau of Investigation. So these are the ones that they revealed to share their data with. And this is Wichita. Wichita has 156 entities, which aren't all listed here due to the space of the slide. However, what's interesting to note that when we searched this back in March, as we were preparing for earlier this spring, as we were preparing for this particular study, it was noted that the FBI was listed. And then when we went back out and looked at this same data on September 22nd, 2024, they had the FBI and turned off, and that was there. I think that's interesting to note. So there are, again, 156 entities here that they network with. Round Rock, Texas had way too many to list. It had approximately 347 external organizations with access to all these entities from, and they're listed in alphabetical order. I have that if you want a hard copy of it, but they're At the bottom line is the ATF in Nashville, Tennessee. Some cities aren't always big into transparency, and there was a concern there with the in Edmond, Oklahoma. The transparency portals for them and also the police department don't disclose which agencies their records are being shared with. And Flock user can upload a list of vehicles into Flock and request notifications when a target passes by a scanner. This feature has been used to monitor specific individuals and alert those individuals that enter into the city. However, the people that they share that with is not available. And perhaps owing to its larger footprint and the presence of Interstate 44, TPD's Flock camera system registered 700 times as many hot lists over the past month compared to Edmond. And with the cameras, TPD registered more than 1,500 hits, and officers were more than 1,900 searches. Interconnectivity among thousands of law enforcement users allows searches from remote locations. Law enforcement agencies can monitor the movement of a target even far removed from the surveilling officer. Custom hot list monitoring by requested notifications even when the target vehicle passes a scanner. They can this feature has been used to monitor specific individuals and alert city police whenever those individuals enter or exit a city. This process does not require making any citizen a potential subject of this warrantless surveillance. When the target vehicle passes a scanner, the Flock user receives a real-time notification on their phone. The ability isn't likely limited to Flock users who are in the close proximity to the scanners, but could potentially be used by distant, faraway Flock users. An FBI user in Washington, D.C. might set an alert for Edmond, Oklahoma resident, provided that Edmond has authorized the sharing of the data with the FBI. This fact isn't known because Edmond has reportedly refused to disclose agencies to the agencies that have access to the Edmond scanners. So there's no transparency there with Edmond. And again, as one of the prohibited uses that are listed on Del City, Tulsa, Oklahoma, and Round Rock, Texas, is immigration enforcement and those other things there as listed as prohibited uses. So not only is Flock into trying to transform America with their technology and create a new type of America, we also have another person named by the name of Mr. Ellison, who is the billionaire Oracle co-founder, and he has the same vision for America. At the end of the month, this post on X related to this ARS Technica article where Ellison expressed the similar vision to Mr. Langley. Ellison said a surveillance system of body cams, police body cams, cameras on cars, autonomous drones, all monitored by AI, will constantly record and report on police and citizens, leading everyone to be on their best behavior. This article states Ellison's vision bears more of a passing resemblance to the cautionary world portrayed by George Orwell's prescient novel 1984. In Orwell's fiction, the totalitarian government of Oceania uses ubiquitous telescreens to monitor citizens, constantly creating a society where privacy no longer exists and independent thought becomes nearly impossible. But Orwell's phrase, "Big Brother is watching you," would take on a new meaning in Ellison's tech-driven scenario, and also Mr. Langley's, where AI systems rather than human watchers would serve as ever-vigilant eyes of authority. Once considered a sci-fi trope, automated systems are already becoming a reality. Similar automated CCTV surveillance systems have already been trialed in London Underground and at the 2024 Olympics. And the article went on to say, China has been using automated systems, including AI, to surveil its citizens for years. In 2022, Reuters reported that Chinese firms had developed AI software to sort data collected on residents using a network of surveillance cameras deployed across cities and rural areas as part of China's Sharp Eyes campaign from 2015 to 2020. This one person, one file technology reportedly organizes collected data on individual Chinese citizens, leading to what the Economic Times called a road to digital totalitarianism. And in my opinion, this is more than just about catching bad guys. We're on the same road to China as they are with this digital totalitarianism. So with that, let's take a look at a real-world example I received from a man in Texas who asked me to show this video to people. And what I've done, this is a 28-minute video. However, what I've done is I've taken clips out to stress the point that of the situation that he was stopped for, and then what the law enforcement officer was able to confront him with inside the vehicle and talk about what that is. So, no, that's fine. We can replay it if we have to. And hit this. Okay, there you go.
You have your driver's license, sir? Yes, sir. Perfect. You cross the fog line. I just want to check and make sure you're not intoxicated, okay? I'm sorry, what? The fog line, the white line right here? Yes, sir. Yeah, you crossed over the fog line.
You got that on
Yes.
camera?
I'm not writing you a ticket if that's where you're trying to get at. I just want to make sure you're not intoxicated. How are you?
Hi.
You have your driver's license, sir?
Yes, sir.
Perfect. You cross the fog line. I just want...
Okay, again, this video was from the individual that was stopped, and it was through a request for Freedom of Information Act, and so please play clip number 2. That's on 23, page 23. Yeah. All righty. Okay, there we go. So he's been stopped and asked to enter and asked to sit in the vehicle with the law
You said you're
enforcement.
coming up to see a friend?
Yeah, I said I was coming up here to see someone.
You come up this way very often then?
No.
No? All right, you don't have any outstanding traffic tickets or anything like that?
No.
Okay, never been in trouble, never been arrested?
No.
Okay. You having a good day?
Okay, all right. All right, the next video. Yes, okay.
And you don't come to Oklahoma very often?
I'll be west of Huntington Falls by the tracks. It's like a
You sure?
just got a fire going over there.
Yep.
You didn't come up on March 10th? No?
34 is en route to 25's location.
I don't know what you're talking about, March 10th.
I'm just asking if you came to Oklahoma on March 10th.
What was March 10th?
I don't know. Or January 20th? Or January 11th?
Oh, around the holidays.
Well, that's after the holidays. And you don't come to Oklahoma very often?
Yes, go ahead and play that one.
What, you got plate readers?
I mean, yeah, there's some on the front of my car. So that's all I was asking. I mean, obviously you're coming to Oklahoma for something.
Yeah, friends.
Okay. Well, I mean, if I ask you come to Oklahoma very often, you tell me no. Kind of, if you're gonna lie, it kind of makes me think that there's other stuff going on than just just coming up to visit somebody.
Came up in January and came up in March.
Okay. You stay for a couple days or?
I don't normally stay up here.
Are you all right?
Yeah.
Are you sure? Because you're increasingly getting more nervous the longer this conversation goes, the more we talk about your travel to Oklahoma.
You're exceeding your...
No, I'm not.
What, you got plate readers?
I mean, yeah, there's some on the front of my car.
And the final one, number 5, please.
Especially with the increased nervousness. So there's nothing illegal in the car then? You're not coming up here to get anything or do anything you shouldn't?
Well, I never crossed the line, so...
Well, I beg to differ about that. But you didn't answer my question. Is there anything illegal in the car? Or any reason you're coming up here to get anything from Oklahoma to take back to Texas?
So you're one of these trained observers?
Trained observers?
Yeah. Tell me about your trained observer.
No, I'm just a cop.
Out with Brandon again.
That's all I am. Is there something I'm supposed to be? No?
Okay, thank you. All right, so clearly the main point here is that his travels are recorded and being retained by law enforcement, and what seemed to be just a traffic stop of crossing the white line. It went a little bit further than what the individual had expected and was truly troubled by it. And so this is a problem, folks, that we have with this data that they are tracking, and they do have that recorded. And
Representative Gann,
yes.
if I can ask you on all that video, did they provide him the video of him crossing the line either?
He did not send me that. When he contacted me after our spring session, he just sent me the video, and this was the body cam of the law officer from that he requested. But no, he did not include that.
I just wonder if they had that too, or
But
if they did not.
Oh, all right. So the video is 28 minutes long, and if you look at the end of the video, the conversation leads to a search of his vehicle. His vehicle is searched by the law enforcement officer, and so then at the end of the video, then comment, and don't hold me straight to the quote, though, that he mentions to the other officer that had showed up that this individual would likely be mad. He used another word because he told the other officer that he truly stopped because of the fact that there was a tailpipe hanging low behind his car. So then it calls into question as to why he really stopped him, what he told him he stopped him for, and never really asked any more questions about his sobriety or anything. So I have that video if anybody else wants to watch it, but in answer to your question, no, we did not have that. So there, let's see, skip a page. Okay, so that's a real world example here of what's happening in Oklahoma and with what's happening and with the use of this data. And we've had some pushback already occur through the courts in McLean County. And as everybody knows by now, that there has been a lawsuit that involved some individuals, and the attorneys asked the judge to suppress the vehicle data, the APLR data, because it's obtained illegally, because there's no state law allowing for its usage with that, only for the compulsory insurance law. And the court agreed. And so we're not only seeing this in Oklahoma, but other places. And it's interesting, if you go out and read that court case, it makes a lot of really good statements and covers a lot of things that have happened nationwide. And in Senator Weaver's interim study last month, Senator Brooks asked former Tulsa Police Chief Wendell Franklin about an opt-out provision from having your tag read. And of course, Chief Franklin's response was just simply don't drive. But within that McLean County lawsuit, in referring to Carpenter versus the United States, which Carpenter versus the United States was a court case which protected the Fourth Amendment rights of people who travel with cell phones, that they can't ping the cell towers and then gather that data without a search warrant. So they were successful on that. But I think this best says, in response to Chief Franklin, is as with cell phones, cars have had long been since a pervasive and insistent part of daily life that for many individuals, owning and driving one is indispensable to participation in modern society. It's really, don't drive is not an option. And that's why it's important that we work towards a solution here legislatively. And then in referring to United States versus Yang, it says the lawsuit states our vehicles take us to sensitive and private places like our homes, doctors' offices, and places of worship. And yet for many years now, with little or no oversight, law enforcement agencies and private companies have been quietly scanning and recording the locations of billions of vehicles, license plates across the country. But we've also seen a lot of pushback in other areas besides license plates. We had A.G. Paxton, the Texas Attorney General, won a lawsuit against Meta for the privacy data that they were collecting through the use of their Facebook. And then he's also going after General Motors, who's allegedly illegal activity of collecting private information off the drivers and using that information without consent. So there's a pushback on the technology and on the privacy issues. And so I think we're going to be seeing more of that. In referring to the lawsuit also referred to the Commonwealth versus McCarthy. Said ALPRs, are only able to capture this wealth of information due to technological innovation. Their computer-controlled camera systems automatically capture images of everyday license plate that comes into view. These systems collect and store data on every vehicle they encounter, regardless of whether the individual drivers are suspected of criminal activity. This data includes not just the plate number, but also a photograph of the vehicle, detailed time, data, and location information that can place the vehicle to within feet of the original scan. And then again here in 2016 and 17, U.S. law enforcement scanned 2.5 billion license plates, 99.5% of which belong to vehicles unassociated with criminal activity. This data, ALPR data, can be used not just to identify and locate a particular vehicle, but also when combined with other easily accessible data, you can identify vehicle owners and drivers. And because the data is stored for years, this ALPR database allows for retrospective searches that enable law enforcement to infer driving patterns, associations, and sensitive details about drivers' lives. At bottom, and this is also from the lawsuit, searches of automated license plate reader databases threaten to undermine the degree of privacy against government that existed when the Fourth Amendment was adopted. And because police have the capability unimaginable in the past, the ability to enter into a virtual time machine and view suspects' past movements to prevent this capability from feeding to permeating police surveillance of the Fourth Amendment warrant requirements. And that was again in the United States versus Yang lawsuit. And here's some other cases. There's a body of case law that's building over the recent years. You've had these series of cases that have been notable, especially the one Carpenter versus the United States, that determined that the tracking of a person's movement using cell phone location information without a warrant violates the Fourth Amendment. And I think it's very easy to form a similar conclusion about autos traveling about on a highway. The precedent of Carpenter was extended to by the Fourth Circuit in a case known as Leaders versus Baltimore Police Department, holding that the police cannot perform aerial surveillance with high-resolution cameras without obtaining a warrant. This led to the suspension of the aerial surveillance program. And courts have already started to rule against the flock system, with a recent ruling in the Virginia District Court being one of the latest examples. In this case, the district court suppressed flock data due to the Fourth Amendment issues of some in the federal case precedents described above. So in the Oklahoma case, the flock data was suppressed because of the lack of state law. In this particular district court, it was because of the Fourth Amendment violations. This places ongoing cases that are being prosecuted based on flock surveillance evidence into legal jeopardy. As more defendants litigate their cases, there can be an increasing number of court rulings further jeopardizing these cases. While this may not pose a significant risk profile for minor cases, eventually a series of high-profile prosecutions will be at risk due to the police's new and frequent reliance on a constitutionally untested system. While the district courts are likely to suppress flock-generated evidence on a case-by-case basis, eventually federal cases will be filed, putting all flock-obtained prosecution at risk. Once the federal courts rule against these systems, traditional public right-of-way surveillance tradecraft may also be effective. This places commonplace, traditionally accepted methods of police work at risk, as the use of surveillance systems unrelated to flock or other interconnected plate scanner system is common for high-profile investigations. These legacy systems are now potentially in legal jeopardy, which is why law enforcement is well advised to tread cautiously in this area. Local officials should not rush forward with the implementation of flock technology that is likely to be held unconstitutional. Doing so could not only result in the release of individuals who have committed serious offenses, but also endanger commonly used investigative techniques. Norfolk judge rejects police flock camera evidence without a warrant. And this is the one I was talking about, where this is the Commonwealth of Virginia. It says there at the bottom, it says, for the reasons stated therein, the defendant's motion is granted to suppress this. The matter, excuse me, the matter that becomes before the court of the defendant's motion to suppress pursuant to the 4th and 14th Amendments of the United States Constitution, Article 1, Section 8, 10, and 11 of the Constitution of Virginia, Statute 19.2, 266.2 of the Code of Virginia. Specifically, the defendant moves the court to suppress the photographs of the vehicle the defendant was driving from the flock automated license plate reader, as well as the defendant's incriminating statement as the fruit of the poisonous tree, because the Norfolk Police Department did not seek a warrant to obtain the license plate information from flock. So the fruit of the poisonous tree, for those that aren't legal beagles like myself, I had to look this up, is evidence that's obtained illegally. The logic of the terminology is that the source of the tree of the evidence or evidence itself is tainted, then anything gained from the fruit is also tainted as well. And that's what that means, and that's in the Commonwealth of Virginia. It's interesting to note, too, that there are other types of lawsuits. There's a class action lawsuit that wants a company scanning and selling Californians' license plate data to pay up. And the trial was scheduled for May in a case affecting millions of California drivers. The company says it did nothing wrong, as it was reported on February 24th in 2024. The company readily advertises the fact that it scans plates, and on its website, the company DRN even calls itself a leading expert in license plate technology and analytics. And the company's cameras scan over 220 million license plates a month, the website says. The customers can use data and create comprehensive vehicle stories. So they did not, so the class action lawsuit hit a roadblock in May, but the case is still being litigated as far as I know. I had not checked this lately. Then in Illinois, another lawsuit, excuse me. Illinois sued over the proliferation of license plate reader cameras. This was from the Center Square, May 31st, 2024. Every time you drive one of these expressways, they are tracking every time you go past one of these cameras, he said. They're feeding into a national database which is shared by thousands of law enforcement agencies across the country. While Stevenson said the dragnet may help track a fleeing criminal suspect, it's capable of tracking much more. Every time you went to the doctor, every time you went to the political rally, Trump rally, a Joe Biden rally, a Black Lives Matter rally, an NRA event, he said the lawsuit argues the system is a violation of Fourth Amendment rights against warranted search and seizure. The permanent tracking of every citizen on all their travels and whereabouts is a bridge too far, he said. Automated license plate readers aren't just being used to the public sector, private properties like homeowners associations, shopping malls, and movie theaters are using them. And the difference is the movie theater can't throw you in jail, can't throw me in jail, and that's the power governments have, and that's why we have more restrictions on government's ability to track our whereabouts at all times. And that brings into a situation where the company that's supplying this data or allowing their technology to be bought and sold almost becomes a state player. Remember, 1620 was to authorize the automated license plate readers on right-of-ways, and this is a big deal. This is something that I think, as I understood in the interim study with the Senate, that the Department of Transportation, OTA, was a little bit reluctant on having that done. They didn't want any part of it, so from what I understand, or didn't want to maintain it, but yet the will or the want to put it on the highway right-of-ways in the state of Oklahoma is still there. Concerns. In last month's Senate interim study, law enforcement was quoted as saying it was as if the lights came on. The license plate reader system, scanner systems, are often touted as a magical tool, enabling police to solve crimes in ways that seem too good to be true. And indeed, that's because from the perspective of the Constitution, it is. As courts have already started to rule against the flock system, as with the ruling in Virginia that suppressed flock data due to the Fourth Amendment issues, eventually federal cases will be filed putting all flock-tainted prosecutions at risk. These legacy systems are now potentially in legal jeopardy, which is why law enforcement, again, is well advised to tread cautiously in this area. Local officials should not rush forward with the implementing of this flock technology that is likely to be held unconstitutional, and doing so could only result in the release of individuals who have committed serious offenses but also endanger commonly used investigative techniques. And the other concerns that we have with this, and these were some that we tried to get implemented last session to solve on the bill that was not heard in the House, flock user queries or searches the system for every Ford pickup. So this is guilt by association that we need to consider when we're writing legislation that past the scene of a crime method can sweep up numerous innocent individuals just by driving a red Ford pickup. And then we have mission creep, seeking approval of the surveillance system. Local police chiefs often find and highlight critical use cases such as locating missing purses, recovering stolen vehicles. However, the omnipresence of the tool quickly tempts law enforcement to become complacent, potentially abandoning best policing practices. Instead of thorough investigations, officer may rely too heavily on flock for a wide range of cases, extending beyond the original intent of the system, as we saw in the previous video clips. And then, of course, there's hacking threats. And while the agreements stipulate that law enforcement has technical ownership of the data is stored in the Flock cloud, and where security is outside the control of the local departments. Then there's the National Surveillance Network. As local police seek approval for this system, they are likely to present the Flock network as a local-only system where departments own the data. However, they won't likely explain that there are thousands of Flock users in other jurisdictions at all governmental levels who potentially have access to conduct warrantless searches on local surveillance. This potentially includes users from heavily politicized agencies as the FBI and the ATF. And when local police departments give federal Flock users access to their scan data, local enforcement is essentially established their city as another node on a nationwide surveillance network on behalf of federal agencies that have little or no accountability to local voters. When these agencies act inappropriate and violate the constitutional rights of individuals, there is often little recourse available to the victims. This is because the officer is not subject to discipline by the local department where the target resides and exercises a right as a voter and a citizen. And we covered the national, the direct and indirect sharing there. We covered that earlier. And then also something else we mentioned earlier was selective enforcement. The constitutional principles are undermined when there is selective enforcement, when law enforcement uses the technology to target a group of people but not others. And then the selective enforcement of Flock technologies is well documented. Some jurisdictions in certain states say they use Flock policies for immigration enforcement, creating a perception of do not use Flock policies for immigration enforcement, creating a dual system. And then we have hot list noise. Flock systems appear to be generating too many National Crime Center hot lists, too many reasonably to attempt to enforce. And then targeting the innocents, Oklahoma departments have reportedly been entering a custom hot list that triggers a notification whenever certain individuals enters or leaves their city. And then, most important, this is not authorized by state law. The defeat of 1620 is consistent with Oklahoma's long-standing culture that prohibits automated law enforcement procedures. All the while, Oklahoma has long recognized the importance of human police officers who can adjudicate their duties through the lens of human common sense, good judgment, and not through the uncaring eye of an automated enforcer. Oklahoma law enforcement leadership suggests that the ultimate outcome of these devices could be the replacement of human officers, a consideration that deserves significant thought before law enforcement is handed over to an automated intelligence. Oklahoma agencies' failure to provide transparency is problematic. We've seen that with the Edmond Police Departments, whose arrogant refusal to provide NONDOC, a well-known reporting agency, any information about their Flock system. And then the lack of government governance and controls. With the proliferation of these systems, local level police departments and local city attorneys are ill-prepared to develop, deploy, and implement and enforce this complex control, a series of complex control policies necessary to provide ongoing and good governance and prevent abuse. And then gaming the system, as we well know, that while designed to enhance security, has an unintended consequence. It does not identify the individual operating the vehicle. So this can lead to stolen identity type situation and have innocent parties presumed to be guilty. And once criminals understand what their out is and their personally owned vehicles can be traced back to them, they will adapt, as they always do, by exploiting the system's vulnerabilities. I want to thank you for listening today. I want to thank you for those who participated in the interim study that are here today, and the state of Oklahoma is woefully behind the technological advancements with automated license plate readers, and our statutes authorizing and regulating their use is very narrow at this point. So it's my goal, and I hope it's the goal of others in both chambers, to develop policy that will regulate the use of this technology that really threatens our individual freedom, all of us. First and foremost, it's our duty to the Constitution of the United States in the state of Oklahoma. And with that, Madam Chair, I'd be open for a few questions, but it looks like we're right on time. So
Thank you, Representative.
we could go to the next one, I guess.
If we can, members, do you have any questions? Actually, I have a couple, Representative Gann. When you talked about the flock in particular, I was curious, in any of your research, did you come across businesses being linked at all so that they might have a flock camera inside their business or on the front of their business linked to any that were like citywide, so that you had a crossover from private to public?
Well, I think there's some, you see these towers in parking lots at the big box retailers and things, but you also see with the doorbells, the Ring doorbells. The research that I found out about that is that there are emergency clauses in a lot of these contracts that are signed, that in the case of an emergency, then law enforcement can go into that data wherever it resides on the cloud, and often it would be on Ring servers, or it would be on the apparatus that may be out in the big box retailer, and they have that ability through those contractual provisions to go in and tap into that data.
Thank you for that. Also, what I was curious about, you mentioned HOAs, homeowner associations. And you may not at this time have thought about this, but I'm curious about any legislation that might need to be thinking about a homeowner association where a neighbor, someone's already built their house, they live there, where it's an optional association, but then an association decides they want to put in these flock cameras themselves. What kind of protection for that homeowner that's already got probably their largest investment that they have, now being told that they will participate, because they've been outvoted perhaps in their HOA, how that would go? Did you look into any kind of regulation on HOAs and flock cameras or Ring cameras?
I did not look into any regulation regarding that particular scenario that you had. The only thing that we covered was the fact that they want them on every street corner, and Mr. Langley's vision is to have a flock camera on every corner, and that would include homeowner associations. But I did not get into that. No.
I just know we've already had some homeowners associations here in the metro vote to put them in their own neighborhood association in their neighborhood. I just thought that was interesting. It came up last night at a meeting I was at. With that, I think we'll pause for a moment, take a 10-minute break. I would like, before we do, let me go ahead for sake of the room space. Anybody that's planning, that's on the agenda to speak today, please feel free to go ahead and move up to the table, even if you're not next. That will free up a little, because I see a lot of people would like to come in and they don't want to intrude when there's not room around the perimeter to sit. So anyone that's speaking today, please feel free when we come back from the meeting, or when we come back in, to sit at the chairs, and we'll take from there. And with that, we'll stop for 10 minutes, and so we'll start back up close to 9:45. Oh, sorry, I didn't know. All right, we are back for the state's powers. Representative Gann. Representative Gann, if you're ready, we are live. So if you want to go ahead and introduce your next presenter.
All right, thank you. Thank you, Madam Chairman. Going according to the agenda, we have Don Spencer with Oklahoma Second Amendment Executive Director and his concerns with this issue.
Okay, would that work? Okay. Yeah, I'm Don Spencer. I'm the president of the Oklahoma Second Amendment Association, and you would think Representative Gann would know that as many awards as he's received from us, but that's okay. We'll get that straightened out. OK2A is a state's leading advocate for Second Amendment rights. However, we are not merely a gun group. We are a liberty group that realizes it may take guns to maintain that liberty, and this is one of those liberty issues that we are deeply, deeply concerned about, especially after watching last month's interim study in the Senate. Our concern, too, is incrementalism. If everyone may remember back in your history book that in 1913 we were told income tax would only affect 1% of the people, and within 4 years it went to 80% of the people. We were also told in the 1980s that we just need babies in car seats and everything will be fine, and now we know that even traveling here today that an adult riding in the back seat may actually get a citation for not being seat buckled in. So this is where the incrementalism concern also adds to this situation. I've watched and for years in Oklahoma, OK2A has enjoyed law enforcement that are members of OK2A, so we are not anti-law enforcement. We are not anti-cop. I want to clear that up. We have sheriffs, we have district attorneys, we have legislators that are members, dues-paying members of OK2A, and including 2 U.S. congressmen. So when I bring this issue up, it's not to put down law enforcement. It's actually to elevate them to stay within their oath that they took to protect and defend the Constitution. So like we saw earlier in the video that Representative Gann played, and I had trouble hearing it, but I don't know that you got to the point where it also stated and showed that they also did an illegal search of his vehicle against his will. So the flock cameras not only, one, set up a culture that we can go do this. The second portion is now they're acting out on it. And so that's just one example that's taken place that has been brought to our attention on this concern. I also was deeply, deeply concerned with, and we can see why citizens become so cynical when a former chief of police of a major city in Oklahoma, like you'd mentioned, absolutely said if a person doesn't want to be viewed by a flock camera, then they should not drive. Well, that's like telling someone not to breathe. That just, in this day and time, that's just not a part of what society is. And so I also want to be very clear, too, I can see how this can be a very useful tool because we watched it last month when an attempted assassination was on former President Trump. And the flock camera, because they were specifically looking for a specific person in a specific vehicle, was nabbed within an hour of what had transpired. And as we look forward for Amber Alerts and even Silver Alerts, we see this as a useful tool when they're specifically looking for that specific one. But this dragnet of wide that can be used, we see that there is an incredible opportunity for abuse, and I've already been informed that there is a law enforcement officer that was keeping an eye on an ex-wife or a girlfriend that didn't, and so using a flock camera to personally keep an eye on these things. And we were promised at the interim study last month that, in fact, the question was asked, has there been any abuse on this? And it was extremely reluctant to give up any abuse that had taken place that they know of. And the second problem is it's difficult to find out anything from our state agencies because of they won't give the information they are required to by law through the Freedom of Information Act. So, and the other thing too, is that this information being contained, I'm a CLEAT certified firearm instructor and I teach handgun classes. And so this has been over 10 years ago. But when I had 2 students call me and let me know that they had gone on a trip to Germany, left their guns at home, left their Self-Defense Act license at home, and as soon as they went into customs in Germany, they were questioned if they had guns and what their license was and asking specific information about that license. So how do we know that this is going to be maintained privately as it's for use, official use? I don't know. But like I say, that information is supposed to be locked tight at the OSBI, and it has been abused there or misused or inadvertently put out there, and we have those exact same concerns with this. And so, like I say, I hope the legislation and OK2O will support legislation on the concept that this information is not of a dragnet service, that it's set up for only if we're looking for a specific person in a specific vehicle, and beyond any information be going through warrant, but this holding and keeping information for 30 days, simply, I will be the first one to say, I don't trust government to do what they're saying they'll do. That's what I have to say.
And then we also have all the way here from Pryor, Oklahoma, we had Chris Gantier. He serves as a city councilman for the city of Pryor. We have his statement that he will deliver personally, but then also I have a statement by Councilman Trammell, who could not be here today, and I'll be reading that after Chris. So Chris, you're recognized.
Well, I thank you for this opportunity. I'm going to read this so that I can stay within my time. My name is Chris Gantier, and I currently serve on the City Council in Pryor Creek, Oklahoma. I'm not writing this letter in my official capacity as a councilman, but to relate my experiences regarding the issue of flock cameras inside the city limits of Pryor, Oklahoma. I have been targeted and labeled as anti-police, and this was abundantly clear when on the campaign trail while I was running for re-election. References were made to the members of the local police department as being the source of this claim. The issue of controversy was my position on the use of flock cameras. The police wanted to use these as a tool for the capture of data to assist them in arrest and recovery. The fact is, the vast majority of data collected and stored is not on criminals, but the innocent. The Fourth Amendment to the Constitution states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Flock cameras and the warrantless collection of data is indeed a violation. Governmental agencies have no constitutional authority to seize our data or information. Currently, there's a state law allowing limited use of license plate readers, LPRs, to assist in the enforcement of insurance compliance only. Even so, we do not meet the guidelines to allow our city police department to use LPRs for this purpose. Representative Gann mentioned 100,000 person limit. We don't meet that. Basically, we are allowing the local law enforcement to violate legal and or constitutional limitations to enforce legal compliance on citizens. This is by default a clear example of tyranny. So the promise was made and an ordinance was drafted to prevent collecting information from being released to third parties that were not law enforcement agencies. This is a local ordinance that has no enforceability on anyone outside the city limits of Pryor. It did not stop the Pryor PD from releasing pictures to Facebook of some success stories relating to flock cameras. And by the way, I didn't mention it in here, but names of individuals was given, photos of individuals were given, license plate numbers was given, all in these pictures. I have them recorded. I can show you multiple occasions. And it came straight from the police department on Facebook, Jeremy Cantrell, the chief of police. So, let's see, I lost where I was. Let me go back. So the promise was made and an ordinance was drafted to prevent collecting information from being released to third parties that were not law enforcement agencies. Local ordinance. Let me go where I was. So ordinance limits the storing of data to 10 days. However, the flock contract says 30. So data stored outside of the city can be retained or given to others, and we have no ability to limit or enforce the safeguards. Surely flock would not do such a thing. Section 5.1 in the flock safety agreement says city information can be disclosed. This could include non-public data. Section 5.3 gives flock the authority to disclose collecting information if they feel necessary. Section 11.8, publicity, says the following. Flock has the right to reference and use customers' name and trademarks and disclose the nature of the services and business and development marketing efforts. Notice there are no limitations mentioned as to what and how it would or could be used. Section 4.2, customer grants Flock a non-exclusive, irrevocable, worldwide royalty-free license to use the customer's generated data for the purpose of providing Flock services worldwide. So basically, Flock can use our information at their discretion without limitations. Our data can be transferred to foreign entities or nations. So if the software originates in another country, a foreign government could potentially require access to data on innocent American citizens. As stated before, there is no statutory protection outside of Pryor, especially if data transfer occurs in another country. When I pointed out some of these potential issues, I was persecuted and labeled as anti-police. I'm pro-Constitution and for the protection of the rights of my constituents. In fact, I swore an oath to do so. Law enforcement touts this will allow us to be safer. The government has the responsibility to protect our rights. These rights are given by God, not granted by government. Therefore, the Constitution is written to protect our rights from the government. Benjamin Franklin once said, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Though the statement's context was dealing with a tax situation, I believe the principle is a valid one. It is the duty of all elected officials to protect the rights of the citizens. To this purpose, I will continue my fight in spite of resistance from those who took the same oaths and should be allies. Thank you.
At this time, I will be reading the statement from Councilman Trammell. Introduction. In 2023, the Pryor Creek Council approved the purchase of 4 Flock automatic license plate recognition cameras using funds donated by the Cherokee Nation. Of the 8 members of the City Council, I was only one of 2 that voted against the purchase. During the initial discussion and debate, I made several arguments on why Pryor Creek shouldn't purchase the ALPR cameras. My argument centered on data retention periods for scanned images and the potential for mass surveillance. Taken together, these 2 concerns have significant impact to not only the citizens of Pryor Creek, but to anyone that has their license plate scanned by the ALPR cameras. Data retention periods. The contract for the purchase of the 4 Flock cameras stated that all images of scanned license plates would be deleted after 30 days. I argued that if a scanned license plate doesn't match a plate on the list of wanted vehicles, those images should be retained for a much shorter period, if retained at all. I proposed, if retention was needed, a minimum storage time of 15 minutes for unwanted license plates should be sufficient. A representative from Pryor Police Department countered my argument, stating that a crime isn't always known to have occurred until much later, and the 30-day retention would allow the police to identify all vehicles in the area to identify potential suspects. The comment should be alarming to any advocate for privacy. Basically, the representative was saying that the Flock safety cameras will allow the police to go back in time and literally observe all citizens' movements around an area where a crime occurred. If these automated license plate reader cameras provided the capabilities to do this, don't they also provide government officials with the capability to observe citizens' presence at activities that would normally consider an intrusion of privacy if monitored in other ways, such as going to a gun store, a political rally, or a particular doctor? In addition, Oklahoma doesn't have a law requiring images of license plates taken by these cameras to be deleted after a specific time frame. We can only rely on Flock Safety to delete images after 30 days as stated in the contractual agreement. Furthermore, there's no assurance that the images aren't transferred to another database before deleted from the official database. Although flock safety states it doesn't do this, we are again having to rely on its word because Oklahoma doesn't have a law restricting this type of data transfer. Mass surveillance. I also argued that the 4 flock safety cameras installed in Pryor Creek would be tied to a network of thousands of other flock safety cameras. This network provides government activities the capability to perform mass surveillance of citizens' movements not only in their local communities but across the entire country as more and more state and local governments are installing them. During the City Council meeting, I highlighted the following comments made by a 2022 report by the American Civil Liberties Union. Altogether, Flock ALPR network adds up to a system of mass surveillance, a system that seems poised to expand beyond just license plate recognition. Mass surveillance systems have long been feared by people who value open, democratic societies, and for good reason. The ability to access a record of all our activities, even if just when we're in public spaces, conveys the power to learn an enormous amount about our social, political, sexual, medical, and religious lives. Mass surveillance simply gives too much power to those who control it. Such power lends itself too easily to abuse, chilling people who might want to protest and those in power, or otherwise exercise their freedom of expression, and generally casting a pall over people's freedoms to live their lives without being watched. End quote. The system of mass surveillance is further exacerbated by the fact that the images taken by flock safety cameras can identify more than just vehicle plates. In fact, flock safety acknowledges that it creates images to create a vehicle fingerprint that, in addition to license plates, is searchable for such features as vehicle make, type, color, covered or missing plates, or even features like bumper stickers or roof racks. The capability provides the greater opportunities for government activities to perform mass surveillance of citizens' movements across state lines. Because Oklahoma doesn't have a law to regulate the use of automated license plate cameras, our citizens are subject to constant monitoring of their movements. City ordinance related to the ALPR. After the City Council voted to allow the installation of the flock safety cameras, it directed that the cameras not be actually installed until a new ordinance was developed and passed to regulate the installation of and use of the cameras. While the proposed ordinance did limit the retention period to 10 days, I proposed that the retention period be further limited to only 15 minutes. In addition, I recommended additional requirements be included in the new ordinance that would provide better oversight of the cameras and usage of the data. As in, number 1, a report to the City Council where cameras would be physically located, and a requirement that the cameras couldn't be located without prior approval of the City Council. Number 2, the police department to submit monthly reports to the City Council of all officers and other personnel that had access to the flock system and or actually access the system. And 3, police department to submit monthly reports to the City Council of all non-prior police, state police or agencies, federal law enforcement or agency, and all non-governmental entities, for example, tribes, that requested access to the gathered data, whether that data access was granted, and if granted, what data was provided. The police chief stated that he didn't agree with my proposed changes because it would be limiting his ability to manage the police department. The City Council rejected each of my proposed changes to include the limited data retention to only 15 minutes. The proposal passed as initially written. In conclusion, once the new city ordinance regulating the 4 flock cameras was passed, they were installed on each side of town on the main highways, effectively scanning citizens' license plates every time they come to town. The key observation I made throughout the efforts to stop the installation of flock cameras is that citizens seem more focused on the very few positive hits on wanted vehicle list instead of the enormous violation of privacy rights that the cameras pose, given the lengthy retention periods and opportunities for mass surveillance. I continue to speak out against the use of the automated license plate readers in an effort to educate the citizens on the significant risk they pose to their fundamental rights. Recently, the City Council voted to approve annual renewal of the 4 flock camera systems. There were 3 who voted against the renewal of the cameras, myself and 2 other councilmen who voted against the cameras last year, along with 1 new councilman who was elected after last year's initial vote. Respectfully submitted, Charles Trammell, Pryor Creek City Council, Ward 3.
Thank you, Representative. Members, do we have questions? Representative Gann?
I believe there's a question, if we could venture off the agenda a little bit. We have Marvin Goodman here, who is a former county commissioner from Logan County, and he has a question about what the location of these cameras that are located on main highways within the city limits and what that problem that may pose.
Commissioner.
You're recognized.
Thank you. And Chairman Crosswhite Hader, thank you so much. And Representative Gann, thank you. And committee members, it's great to be here. And thank you so much for allowing me this question. My question has to do with the maintenance of right-of-ways on state highways. State highways and federal highways. I already know the answer to this, being a county commissioner for the past 8 years, 8 years before. It is the responsibility of our lawmakers to help us out in the counties. Counties don't pass laws like municipalities do. We're there to enforce the laws that are generated here in this house. And so my concern is that we have municipalities like the city of Guthrie that passed this flock camera system. They installed it, and now they have placed those flock cameras on state highways, on the state highway right-of-ways. They've been there for quite a while. We've complained about it, and to no avail at this time. My other concern is that if they're able to do that, then the interstate highway, I-35, is also in their city limits, their domain. What's to keep them from placing those cameras on that inside their city limits? They claim domain because it's inside their city limits. I would say, based on my experience in working with ODOT for 8 years as a county commissioner, that is absolutely not the case, that ODOT controls and is responsible for all the right-of-ways for state highways and all of our interstate highways as well. In that regard, I'm just asking the question, who's going to enforce the law? Because they're breaking the law today by doing that. That's my question. Thank you.
Thank you, Commissioner. I think we have the same scenario, and this is a question for ODOT. If we could find out, because these cameras are set on right-of-ways of state highways, but then fall within the city limits of a municipality, who governs? And if you have an answer, we'd sure take it today. If you're welcome to come and turn the mic on for her, Chris, right there, and get her a mic. Yes. Yeah.
If you would just give us your name and title, please.
My name is Dawn Sullivan. I'm the Deputy Director for the Oklahoma Department of Transportation. And with me today is our Chief Traffic Engineer and, of course, Monty Smith, our Legislative Liaison. We do not currently permit or allow these cameras on state property. We have been approached, but we were very clear that we need clear statutory authority to do so from this body before we would permit any of those cameras. We are aware of a few instances where cities have taken it upon themselves to install them in our rights-of-way. We are attempting to have them removed and are continuing to work on the ones that we are aware of. we're working on it, but, and as we become aware of them, we will seek to have them removed.
Let me ask you to that. When you have something in the right-of-way that doesn't have the authority to be there, you just remove it. So why the need to wait to get approval to remove these?
I think we're asking the people who had them installed to remove them is the issue. We, as far as we don't want to be accused of damaging anybody's property. So that's our first option. We would prefer that the folks who own them and installed them remove them.
Can you give us a ballpark of how long you've been working with that, waiting to get them removed?
I'm going to ask phone a friend. Do you know how long we've known?
As soon as we know, we work on crews to be pulled down.
Okay. So this one, how long has it been? A couple weeks? Yeah, we'll have to find out. I don't know. I don't have a clear timeline, but we are aware of this particular issue. I just discovered it this morning, but I know it's something that we're working on. Our district engineers are aware that this is an issue.
If you want to go ahead and just sit down, I think you're going to have some more questions. All right.
Yes.
Representative Banning, did you have a question?
I will allow the questions to finish up here first, if you don't mind, Madam Chair.
Councilman, you want to go ahead?
Chris Gantier, counsel in Pryor Creek. So if they're in the right-of-way and they're not legally supposed to be there, shouldn't they be impounded pending an investigation? And shouldn't they just go ahead and take them?
I believe that's something that we could consider doing. The right-of-way is under control, obviously, of our district engineers. We try to be good neighbors to our communities. We would obviously like to work with them to resolve the issue, but if push comes to shove, something that's not permitted on the right-of-way can be removed.
You have a question?
Any other? If not, Representative Gann or Representative Banning, either one of you.
Okay, so right now, does ODOT have any idea on what it would look like should there be statute passed that would allow flock cameras to be on right-of-ways, whether in city limits or on state right-of-ways anywhere? Do you have any studies that show what would be required, like the size of pole, the base, how far off, the weight of the camera? There's a lot of it due to the possibility of an impact by a car. I mean, you would have to go through an extensive study just to be able to figure out how these things would be planted.
We do have standards that we would require that they were adhered to about, impact and such, but specific to sign standards, our chief traffic engineer would probably be best to answer that question, but we do have set standards and expectations on anything that's installed in our right-of-way.
Follow up? So any statute would have to incorporate that standard, or would that be by administrative rule? Do you know?
It's in our administrative code.
Okay.
I'm advised it's already in our administrative code. Thank you.
Thank you.
Representative Banning.
Thank you, Madam Chair. And before I start, I just want to say that I greatly respect and appreciate your leadership style. And we need more leaders like that take the least amount of resistance first. I appreciate that. And then take the next one. Thank you for that.
No other questions? All right, Representative Gann, if you want to move along. Oh, I'm sorry.
For follow-up, that was to address this. So
I'm sorry, I thought maybe you had
on the
a
way
question.
here, this is and I hope I don't take too much time here, but on the way in, I was going to another interim study, and I had 2 text messages saying, "Are you listening to this? What's happening in this committee?" And I listened on the way in, and that's why I was late. My background is I'm a security professional in government entities. This is what I do. This is how I've made my business. We've installed the only nuclear-ready security system in the nuclear-ready hospital in the world at Osan Air Base, South Korea. Special warfare, SEAL teams, we've done security installations for the best of the best. And I can tell you, if anybody's telling you that this software is only going to identify that, they're misleading you. I don't like using the word, they're misleading you. If they're saying that it's only going to scan for 15 days and acting like one button can't be pushed to allow that to go further, or one PSP professional to allow that to go further, they're misleading you. This security needs to be taken seriously, and it is a clear violation of our of the Constitution in my eyes. It truly is. It was hearing some of the police footage on the way in was just really disturbing, to be honest with you. When he was going down the list of, this was in March and February and January. I wish I would have been in that car, because I typically have the Constitution with me. So show me where this is legal, where you're doing this. But I tell you what, in this, when we were installing the last security system for a skiff at Tinker Air Force Base, that it rolled back to that, and me talking to my security professionals, and they were asking, "What parameters do you want me to set in this, sir?" Those are parameters that I was given the direction. That's all it has to be, is a direction to say, set these parameters in this security software, and it's done. I can't imagine Flock software, and I don't know that much about Flock software, but it's software. And I can imagine that it can be moved and manipulated however it needs, because someone invented that software. So I just wanted to make that clear, that this can be moved if it is software.
Representative Banning, while we do have you here, did you have any other questions regarding the video that we watched while you were not in the room but listening online? Did you want to direct any questions to Representative Gann regarding the police officer video?
Yes, thank you, Madam Chair. So in the video, it stated that the camera was on the front of his car, but was that accurate, or was that a Flock camera somewhere else that was recording?
No, there are license plate readers on the vehicles themselves.
Okay. So that's what he was talking. Was it a Flock reader or it was just a?
Whether I don't know who the vendor would be for police departments. I don't know who the vendor is, but he did mention that it was on the front of the car.
And I want to be very clear before we end. I'm not coming against any software company. This is software in general. Mm-hmm. So I want to be very clear. Thanks.
Representative Olson has that question. If you want to go ahead, Representative Olson.
Thank you, Madam Chair. Regarding the video, it was mentioned that he eventually agreed to a search. And of course, we didn't see that part of the video, but was he strongly encouraged, as in, well, we're going to have to get the dogs if you don't agree right away, or it's going to take some time? Or did he specifically say, no, I'm not authorizing it, but I won't physically stop you?
If my memory serves me, I think he said the outside only is what he allowed the officer to do. That was his response.
Okay, thank you.
Seeing no more questions, Representative Gann, if you want to move forward, or do you have another question still on this?
I don't have a question, but I do have a statement I'd like to make in that Forbes magazine, this seems to be a method of operation with Flock to install these cameras in an unauthorized way in many, many states. They have problems with the unlawful deployment of these cameras in Illinois, Florida, South Carolina, and Texas. And so this seems to be a method that they use to just get their product out. But what in the process, I think it creates a real safety issue when we don't have the requirements that ODOT requires for setbacks and weight and placement and those type of things. So it's really creating an unsafe, would be if they were allowed to be on state right of way without authorization. So I just want to make that point.
Thank you. Representative Gann, then you are recognized to go ahead and introduce your next presenter.
I believe we have Chad Marlowe. Can we get him brought up?
Chad, can you hear us?
I can. Can you hear me?
We can. Just a moment, we're getting your slides.
Thank you.
Just a moment. All right, I think we have you set. If you want to go ahead and proceed.
Very good. Good morning. My name is Chad Marlowe, and I am a senior policy counsel with the ACLU, where for the last decade, I have focused my attention on issues involving privacy, surveillance, and technology. I want to thank the members of the Oklahoma House State Powers Committee for the opportunity to speak to you today. Today I will be testifying about a surveillance technology alternatively known as automated license plate readers or automatic license plate readers, and which are commonly referred to by the acronym ALPRs. My goal today is to provide honest, accurate information about ALPRs upon which I hope the members of this body can rely in making sound policy judgments. I also want to assure the members of this body and everyone in attendance today that credibility matters deeply to me. I was taught early and often that it takes a lifetime to establish one's credibility and a moment to destroy it. That is why I am not going to exaggerate or mislead this body in any way to advance my preferred position on ALPRs. In the end, it is your position that matters, not mine. I understand that in prior presentations to this body, certain ALPR companies have not necessarily adhered to that principle. For example, when representatives of the ALPR company Flock Safety appeared before the Oklahoma Senate Public Safety Committee on September 10, 2024, they claimed that, quote, Flock Safety LPRs are being used to solve 10% of all reported crime in the United States. On its website, Flock makes the same claim with slightly different wording, asserting that, quote, 10% of reported crime in the U.S. is solved with Flock. That's quite a claim, but let's unpack it a bit, shall we? According to the FBI, in 2023, only 26.4% of reported crimes were solved in the United States. As such, for Flock's ALPRs to have been used to solve 10% of all crimes in the U.S., that means its ALPRs would have had to help solve roughly 40% of all reported U.S. crimes that were solved. That's an amazing feat given that most crimes do not involve a vehicle. I can't imagine Flock's ALPRs were used in solving many shoplifting crimes or white-collar crimes or consumer fraud crimes. In fact, only 8.8% of vehicle thefts, a crime in which an automobile is certain to be involved, are solved at all. So Flock's 10% solved claim, even with respect to car thefts, exceeds the total number of crimes solved. It should therefore come as no surprise that the only source Flock cites for its 10% figure is a non-peer-reviewed internal Flock study, and that hidden on its website, but not provided in its presentation to the Senate Public Safety Committee, is an acknowledgement that the figure is merely an internal Flock estimate. Now, I'm hardly the only person to question the veracity of Flock's statements. Michael Sierra Aravallo, a professor at the University of Texas at Austin, said Flock's claims, quote, border on ludicrous. Columbia University law professor Jeffrey Fagan told Forbes magazine, quote, I doubt Flock's internal study would survive peer review. And Jonathan Hofer, a social science researcher who studies license plate reader efficacy for the nonpartisan think tank, the Independent Institute, called Flock's ALPR claims, quote, Exhibit A of lying with statistics. The truth is, ALPRs are no magic bullet when it comes to solving crimes. In fact, they are more like a real bullet, in that if not used properly and safely, they can pose a significant threat to Oklahomans. One final introductory note. My testimony today only relates to the government use of ALPRs. The private use of ALPRs, like the Homeowners Association example that came up earlier, is subject to First Amendment protections and therefore requires a different analysis. If I could have the next slide, please. So what are ALPRs and how do they operate? ALPRs, in terms of their hardware, are digital cameras that can be deployed in a stationary manner, such as by affixing them to a traffic light, or in a mobile context, such as by affixing them to a police car. Once activated, an ALPR will scan its field of view for license plates, and when one is identified, it will capture an image of that plate, digitize its information so a computer can read the license plate's number and state of origin, and then run the plate's information against specific hot list databases to see if the plate is of interest to law enforcement. The ALPR will also record the date, time, and location of where that plate's information was captured. ALPRs can also generate information on the make, model, and color of the vehicle, and may even record information from its bumper stickers. If the scanned plate is on a hot list, the program will return a hit and notify law enforcement as to why the plate is of interest. How long captured plate information is retained is determined by those who control the ALPR system. Quite obviously, ALPRs are a mass surveillance technology that is capable of capturing, storing, and analyzing thousands of plate images every hour. Next slide, please. When I talk to people about analyzing surveillance technologies from a civil rights and liberties perspective, I suggest that they fall into one of two buckets. The first bucket is for surveillance technologies that are simply too problematic to be used under any circumstances. This can be because they are faulty, discriminatory, or simply present too great a threat to privacy or other important civil rights and liberties to be used safely. The second bucket is for surveillance technologies that present benefits and risks, as all of them do, but where strong, thoughtful laws governing the technology can create guardrails that enable it to be used safely in limited contexts. Whether ALPRs fall into the first or second bucket is your judgment to make, and I hope my presentation today is helpful to you in making that decision. So let me start with some general observations about ALPRs. As with most technologies, and most things in life for that matter, ALPRs are neither all good nor all bad. ALPRs have some good uses, like for electronic toll collection and Amber Alerts. But ALPRs can also be highly problematic from a civil rights and civil liberties perspective, like when they are used for fine and fee enforcement, but are only deployed in certain areas like low-income communities, or when they are used to gather location and tracking data on every local vehicle for a period of weeks, months, or even years with no criminal suspicion to justify doing so. Next slide, please. Should the members of this body consider adopting new ALPR legislation, either now or in the future, I would suggest doing so in 3 steps. The first step is deciding if ALPR use should be permitted at all. Do the benefits of using ALPRs exceed its risks to individual rights? If your conclusion is yes, then you proceed to the second question. The second question requires you to determine what uses of ALPR should be permitted. Like with the broader first question, here you must ask, with respect to each particular use, do the benefits of the specific use exceed its risks? Under current Oklahoma law, there is only one allowable use of ALPRs. As Oklahoma Statutes Title 47, Section 7-606.1C1 states, quote, participating law enforcement agencies may use automatic license plate reader systems utilizing individual automatic license plate reader system units to access and collect data for the investigation, detection, analysis, or enforcement of Oklahoma's compulsory insurance law. The third and final question you must ask, understanding the risk that each allowed ALPR use carries, is what rules or guardrails should govern their use in order to safeguard people's civil rights and civil liberties, including their right to privacy. Guardrails can be established for each particular ALPR use or for all allowed uses collectively. For the only permissible use of ALPRs currently allowed in Oklahoma, enforcement of the compulsory insurance law, there is just one such guardrail in place, which is found in subsection F of the authorizing statute. That provision reads, quote, data collected or retained through the use of an automated license plate reader system shall not be used by any individual or agency for purposes other than enforcement of the compulsory insurance law or as otherwise permitted by law. As a general rule, I would suggest that the greater the risk presented by an approved ALPR use, the more stringent the guardrails need to be. And again, it will ultimately be up to your judgment as to whether the risk of allowing any additional uses of ALPRs in Oklahoma can be adequately addressed through the implementation of guardrails. Next slide, please. Before proceeding to discuss these risks and potential guardrails in greater detail, I would like to clear up one issue that Flock's September presentation to this legislature seemed to muddy. Specifically, Flock went to great lengths to point out that several U.S. courts have ruled that, under the specific facts of their cases, the use of an ALPR did not violate the Constitution. That may be true, But just because some uses of ALPRs may be permissible as a matter of constitutional law doesn't mean as a policy matter that their use should or must be allowed. And it doesn't mean there shouldn't be limitations on ALPR use where it is allowed. For example, just because Oklahomans have a legal right to get a driver's license and drive a car doesn't mean the state can't establish a speed limit or prohibit certain vehicles like Formula One racing cars from operating on the roads. So in that vein, I hope the next part of my presentation will spark a thoughtful public policy discussion about if and how government ALPR should be allowed in Oklahoma and how those choices can best be captured in state law. Next slide, please. The most significant threat to civil liberties posed by ALPRs involve personal privacy. The basis of that threat is fairly easy to understand. ALPRs undermine the right to privacy because their data allows the government to track everyone's location and movements. Remember, ALPRs do not merely identify one's vehicle by capturing data from its license plate. When plate data is captured, the ALPR system also records where your vehicle is and when it was there. When ALPRs capture plate information on a particular vehicle over the course of hours, days, or more, what started out as single points on a map now become a series of connected dots that can track when and where a person travels and places they visit throughout their day. This provides the government with access to some very personal and intimate details of your life, such as what religious institutions you attend, what political meetings you go to, what doctor's offices, like a psychiatrist or oncologist, you visit, where you sleep at night, be it at your home or someone else's. The list goes on. And ALPR's privacy harms go beyond location tracking. Their use can also undermine one's ability to be anonymous in public, because ALPRs can be used by the government to know when you leave your home and where you are in public at any point in time. They can similarly undermine one's expectation of privacy in public, because they can make it impossible for people to confidently participate in public activities without being identified, such as when they drive to an AA meeting. And ALPR use can create personal danger, because the data they generate, even if collected by a trusted government agency, may not remain with that trusted government agency. Let's face it, a person may like and trust their local or state law enforcement and other government agencies, but that doesn't mean they trust all law enforcement and all government agencies. Unfortunately, once it's collected, ALPR location data can be easily and widely shared. Beyond the threat ALPRs pose to privacy, I want to highlight two other threats that ALPRs create. The first threat occurs when ALPRs are only deployed or over-deployed in certain communities, leading to discrimination. Elsewhere in the country, we have seen ALPRs deployed only or disproportionately in low-income areas or in communities of color, which is a violation of their civil rights. The other threat I want to highlight comes when ALPR scans are run against unreliable hot list databases. When this happens, and it happens far more often than you might think, it can lead to unjustified stops and false arrests based on bad information, which is a significant threat to personal freedom and liberty. Quite obviously, the easiest way to protect civil rights and liberties from ALPR surveillance abuses is to prohibit the use of ALPRs. This is an option worth considering, but this committee doesn't need my expertise on how to ban the use of a technology. That's a fairly straightforward undertaking. So instead, I want to focus on what guardrails are available for when ALPR use is allowed. I would suggest that these guardrails not only be considered in the context of potential future ALPR uses, but also as to whether they are needed with respect to the only currently allowed use for ALPRs in Oklahoma for insurance coverage enforcement, which, as you will recall, only has one such guardrail in place. So now I'd like to discuss these various guardrails by issue, and if I can have the next slide, please. The first issue involves data retention. The problem here is that the more ALPR data that is captured and the longer it is retained, the more private information it reveals. The solution is to significantly limit ALPR data retention where a scan does not produce a hot list hit and no criminal investigation is involved. As an example, the state of New Hampshire has an ALPR data retention limit of 3 minutes, which is ideal. Again, remember that hits against hot lists can be determined within a matter of seconds. If 3 minutes feels too short, I would strongly suggest that given how ALPRs work, a 48-hour data deletion requirement where a scan produces no hot list hits and is not related to any ongoing criminal investigation is more than enough time. The argument behind longer ALPR data retention periods, which has led to the storage of ALPR data for weeks, months, and even years in other areas of the country, is that you never know if ALPR data could eventually prove to be relevant to a criminal investigation. But for that logic to work, you need to accept the underlying premise that government should view every person as a potential criminal, and that the likelihood of criminality is high enough that it justifies creating what is essentially a criminal file on every single person that tracks their location and movements for an extended period of time. That is a terrifying proposition from a civil liberties and privacy perspective, and I urge you to reject that type of thinking. It is worth emphasizing that when it comes to establishing shorter data retention periods, legislation can and should state that ALPR data can be kept for as long as necessary if it is connected to a specific ongoing criminal investigation or enforcement action. What this means is that short and strict limitations on ALPR data retention are about protecting the privacy of people for whom there is no criminal suspicion and not about protecting criminal suspects. The bottom line is simply this. If someone asks for a longer ALPR data retention period, like Flock's 30-day retention period, you should ask them why they need so much time, given that ALPR plate scans can be run against hot lists in a matter of seconds. I assure you they will not have an adequate answer. Next slide, please. The next issue involves data sharing. The problem here is without data sharing limits, collected ALPR data can be made freely available to other government or private entities, some of whom may be unknown or untrusted, and some of whom will use it for an unidentified or unacceptable purpose. This is not a hypothetical problem. To be sure, it is not uncommon for ALPR data to be intentionally shared with another known and trusted government entity. At the same time, however, it is also not uncommon for collected ALPR data to be shared without the collecting agency's knowledge, or for ALPR data to be automatically shared with the Fusion Center, which then allows any other government entity with access to the Fusion Center to obtain the data. The solution that I would suggest is to limit ALPR data sharing to trusted state and local entities from Oklahoma only, unless the requesting entity has a warrant. The bottom line here is that other states, the federal government, and private companies may not always have the best interest of Oklahomans at heart, and the law with respect to data sharing should reflect that. Next slide, please. The next issue involves the use of unreliable hot list databases. Unfortunately, not all criminal databases against which ALPR data is run are reliable. For example, one of the largest and most commonly used national hot lists, the National Crime Information Center NCIC database, does not even comply with the 1974 United States Privacy Act's basic accuracy, reliability, and completeness requirements. And yet certain ALPR companies like Flock use it for their ALPR systems. This means that people who have done nothing wrong and mistakenly appear on an untrustworthy database are at risk of being stopped and even arrested by the police. If a person is incorrectly listed as being a dangerous felon, a stop and arrest may occur with guns drawn, which is an exceptionally dangerous situation for everyone involved. The solution is to limit the hot list ALPR data can be run against to reliable, well-maintained state and local databases from Oklahoma. Such hot lists naturally reflect the enforcement priorities of state and local police, so beyond being more reliable and accurate, they will be well tailored to the purposes for which local ALPRs are being used. As such, using only state and local hot lists will increase safety and accuracy without compromising Oklahoman law enforcement objectives. Next slide, please. The next risk is the risk of discriminatory deployment. As I noted before, it is not uncommon for ALPRs to be exclusively deployed or disproportionately deployed in specific vulnerable communities, like low-income communities and communities of color. This is frequently done as a means for generating more government revenue from those specific communities or to increase policing in those specific communities. The solution is that where ALPR use is permitted, the law should require ALPR deployment to be equitable and uniform throughout a jurisdiction. Next slide, please. The next issue is what I call Big Brother is watching you for anything and everything. The problem here is that a mass surveillance technology, as powerful as a widespread network of ALPRs, should not be used for minor non-vehicle related traffic enforcement. Traffic stops are inherently risky for both law enforcement and the general public. Recognizing this, where ALPR use is allowed, the law should limit the type of infractions for which ALPR hits can be generated. In terms of the solution, while I readily admit this list is somewhat subjective, I would recommend limiting ALPR hits to the following situations: an unregistered or uninsured vehicle, a vehicle in violation of inspection requirements, a vehicle registered to an individual for whom there is an outstanding felony warrant, a vehicle that is related to or involved in a felony, a vehicle associated with a missing person, a stolen vehicle, for regulating the use of government-operated parking facilities, for controlling access to secure government facilities, and for electronic toll collection. But again, whether that list is adequate or is too long is your judgment to make, not mine. Next slide, please. And the last guardrail-related issue I want to highlight with ALPRs is allowing for the adoption of local ALPR rules. The problem here is, should this legislature choose to allow additional ALPR uses, but then look to localities to create their own ALPR guardrails for those approved uses, then the state will not be able to guarantee adequate civil rights and civil liberties protections will be in place amongst the patchwork of local policies. In fact, taking a local rules approach would mean that as one drives through Oklahoma, the privacy and other rights protections people receive will vary from town to town and county to county. The solution here, I would suggest, is that when it comes to ALPR use, the protection of people's constitutional rights should be reliable and consistent throughout the state. In seeking to do that, having state law establish clear and consistent ALPR rules and guardrails is vastly superior to having each local police department establish their own rules. For the final focus of my presentation, I was asked to discuss why Flock's ALPRs are particularly problematic. Given that I have previously written on this subject and that the piece includes legislative drafting recommendation, with the chair's permission, I would like to submit the blog I authored entitled "How to Pump the Brakes on Your Police Department's Use of Flock's Mass Surveillance License Plate Readers" into the record. It's my understanding that it has already been provided to the committee staff from Representative Gann's office, who can get that to the committee. Flock's corporate approach to ALPR use raises several problems worth highlighting. I respectfully suggest that these problems, which go beyond the company's challenges with telling the truth, should give Oklahoma state and local government entities significant pause. Next slide, please. The first problem with Flock's ALPRs is their approach to data storage. As I previously noted, even though ALPR data can be run against hot lists in a matter of seconds, pursuant to Flock's standard government agency customer agreement, Flock stores ALPR data for 30 days. This privacy-compromising standard allows for significant long-term location tracking, unnecessarily creates a data pool that is a tempting target for hackers, and permits Flock, a third-party corporation, to retain significant quantities of Oklahomans' private location information for an entire month. Next slide, please. The second problem is that Flock's corporate judgment prevails when it comes to with whom locally collected ALPR data is shared. Pursuant to Flock's standard government agency customer agreement, quote, Flock may access, use, preserve, and/or disclose the ALPR footage to law enforcement authorities, government officials, and/or third parties if Flock has a good faith belief that such use, access, preservation, or disclosure is reasonably necessary to protect the rights, property, or safety of Flock, its users, a third party, or the public as required or permitted by law. This means Flock has broad authority to determine if and when it can share locally collected ALPR data with other persons and entities, whether the Oklahoman government entity on whose behalf it was collected likes it or not. Next slide, please. The third problem is that Flock requires it be given permission to share Oklahomans' ALPR data anywhere in the world. Pursuant to Flock's standard government agency customer agreement, quote, the customer agency hereby grants Flock a non-exclusive, worldwide, perpetual, royalty-free right and license during and after the service term hereof to disclose the agency data and non-agency end-user data, both inclusive of any footage, to enable law enforcement monitoring against law enforcement hot lists, as well as to provide footage search access to law enforcement for investigative purposes only. This worldwide license means Flock can provide Oklahoma's ALPR data to any law enforcement in the world, even after your contract is terminated, including to those from oppressive regimes like Russia, Iran, and China, who may have investigative purposes in mind that Americans find repugnant. Next slide, please. The fourth problem is that Flock runs local ALPR data against unreliable national hot list databases like the NCIC database. As noted earlier, the NCIC database is exempted from complying with the United States Privacy Act's basic accuracy, reliability, and completeness requirements. This means a mistaken hit from that database can lead to innocent Oklahomans being stopped and even arrested by the police. Next slide, please. And the fifth and final problem is that Flock wants to make Oklahoma's state and local ALPR data part of its national ALPR system. Flock's stated corporate goal is to expand to, quote, every city in the United States, and to use its local ALPRs, including any ones it deploys in Oklahoma, to build a, quote, national camera network, even if Oklahoma doesn't want its population to be included in such a network. This means if Oklahoma does business with Flock, that Flock customers from Hawaii to Maine and beyond will be able to access Oklahomans' ALPR data. A better option is simply to use local and state ALPR systems and local and state ALPR databases. The big picture when it comes to Flock is simply this. You don't need a hand grenade to kill a bug when a fly swatter will do. Flock's nationwide ALPR system may be the best for its business model, but a local or state ALPR system is far better for Oklahomans' privacy and their other civil rights and liberties. Having focused on Flock here, I do want to be clear about one thing. While Flock's ALPRs are a major concern, Flock is not the only company that is looking to build a national ALPR surveillance system. For example, Motorola Solutions is pursuing a similar business model. So the lesson here is not merely to avoid Flock, but to avoid any ALPR company whose profit-driven Orwellian approach to ALPR surveillance does not align with your own personal values. Next slide, please. I'd like to conclude my presentation today with a few thoughts. There is no question that Oklahoma's current very limited approach to ALPR use, while there is some room for improvement in terms of adding guardrails, does a very good job protecting civil rights and civil liberties. Now, could allowing for the expanded use of ALPRs in Oklahoma continue to protect Oklahomans' privacy and other civil rights and liberties? It's possible, but the devil would most certainly be in the details. Whether you want to take that risk is up to you. And how you would manage that risk in terms of legislating ALPR use limitations and guardrails is also up to you. My hope is that this presentation will be of value to you as you consider these important issues. Next slide, please. I want to sincerely thank you again for the honor and privilege of appearing before you today, and I would be happy to answer any questions the committee may have.
Thank you, Mr. Marlowe. Members, do you have any questions? Representative Banning.
Thank you, Madam Chair. Mr. Marlowe, during your presentation, you mentioned the word guardrails multiple times. Who do you believe is on the backside of the guardrails? Do you believe a human is on the backside of the guardrails making these parameters?
Humans are involved in certain ways. So humans obviously will be involved in determining what the guardrails are. Oftentimes, a technological intervention will be involved in terms of enforcing the guardrail. So, for example, theoretically, if you say all data has to be deleted within 48 hours, then it would be a technological solution that would say that ALPR data is 48 hours old, it has to be deleted. But in order to guarantee those guardrails are effective, I would suggest that there has to be then a human behind that auditing whoever is collecting that information to ensure that those guardrails are actually being adequately and completely enforced.
I would agree. Thank you.
Any other questions? I might ask one. Just when you were talking about the police agencies and how they use the equipment, have we had any examples of the police not following the laws that were put in place to hinder or to restrict or put those guardrails up?
Unfortunately, more than I could possibly cite. I think there was another person who testified who talked about a police using an ALPR system to track someone they were in a relationship with. Yes, unfortunately, ALPRs and ALPR data has been abused, and the levels of that abuse vary. There can be a personal level abuse, like you said, with an individual using it for their own personal benefits. And I think there can also be abuses in terms of when ALPR data leaves a particular trusted government agency and moves on to other agencies or private entities, it can be used for any variety of purposes, and that makes it a lot more difficult to track. Obviously, if someone in Maine accesses Oklahoma's ALPR data, it's going to be very difficult for Oklahoma to enforce any limits on its use, and it may use that for certain enforcement purposes that you guys may say, we never would have allowed ALPR data to be used in Oklahoma for that purpose. So that is a risk of placing guardrails in place where the data is able to flow freely, is the risk of misuse.
Thank you. I have a question from Don Spencer. Go ahead.
Would you give your opinion on whether the enforcement should be done through a civil or criminal action when it is proven that this has taken place?
It would be my opinion, and I want to be respectful. This is my opinion, and that's all it is. I think that civil enforcement is probably the most appropriate. What I would say in that respect is there are some governments who have limited that enforcement strictly to a government official. So, for example, a state could task the attorney general with enforcement, or a locality could task a district attorney or prosecuting attorney with that enforcement. The challenge with that we have seen is that, as you all probably know quite well, those offices have a lot of responsibilities and very limited staffs and very limited budgets. And whether or not enforcement of ALPR violations rises to the level of where they want to dedicate their limited resources cannot be guaranteed. So I think the best path to enforcement is dual enforcement, both by government officials, but also through private rights of action. So if an individual, like the gentleman in that video with the Texas law enforcement, thought his rights were violated, he could bring a private action, and that would reduce some of the burden on the government agencies for enforcing and also increase levels of enforcement.
Seeing no other questions, thank you, Mr. Marlowe. Representative Gann, I turn it back over to you to close out the meeting.
Thank you, Madam Chair. Thank you, Mr. Marlowe. I want to thank everybody that's participated today, and we finished up an hour early, and so I want everybody to have a great day. Thank you very much.
Thank you, members. We are adjourned.